We have the honor today of hearing Dr. Gideon Christian speak about his research on algorithmic racism. So if you all could give your attention to Dr. Christian. Um, the floor is yours, Dr. Christian.
Thank you. Well, good afternoon, everyone, and welcome to this presentation. And I want to thank you all for inviting me to the Center for Ethics here at the University of Toronto. My presentation, of course, is going to focus on my research in this particular area. I just wanted to start my presentation by noting the fact that I'm a critical race scholar. My work centers on using critical race theory to analyze new and emerging technologies, especially artificial intelligence technologies, in order to identify or highlight elements of racism, racial bias, or racial discrimination in these technologies. So this research forms part of my broader research in trying to develop the concept of algorithmic racism, which I define as race-based bias arising from analysis of data and use of AI, artificial intelligence technologies in decision making. As a critical race scholar, I love stories. I adopt stories in my presentation, my discussions, my research. And I'm going to start this presentation with a story. And this story takes us back to a city in United States, Woodbridge, New Jersey. In January 2019, at this hotel, Hampton Inn Hotel in Woodbridge, New Jersey, the Woodbridge Police Department were responding to a shoplifting incident in this hotel. The alleged shoplifter or criminal was able to make a successful getaway, but not without leaving a trace, because the shop in this hotel actually has a closed-circuit camera or CCTV. From that closed-circuit camera or video in that closed-circuit camera, the police departments were able to generate a still image. Using that still image and cutting-edge artificial intelligence technology, they were able to match the face of the suspect to an individual in their database. That individual happens to be this guy, Mr. Nija Park. Mr. Park was then 34-year-old Black male resident of Woodbridge, New Jersey. Based on this evidence from facial recognition technology, the police were able to obtain an arrest warrant. The following month, in February 2019, Mr. Park was arrested. On his arrest, of course, he denied any involvement with the crime, which, of course, is not unusual when suspects are arrested. They don't go ahead and just confess that they did the crime. So there was nothing unusual about his denial of the crime. He spent the next 10 days in jail until his mother and his girlfriend were able to get him a good lawyer and then post good bail bond. And he was released pending his, of course, appearance in court. Outside jail, Mr. Park continued to assert his innocence, denying any involvement with the crime. But when the prosecution offered him a plea deal for him to plead guilty to the crime in return for a reduced sentence, he seriously considered accepting the offer. And that may probably make you wonder, why would somebody that has asserted and continued to assert their innocence want to accept that plea deal? Why would they want to plead guilty to a crime they have asserted that they are innocent? Well, there are many reasons why criminal defendants accept plea deal. We're not going to go into that here. But in the case of Mr. Park had a previous criminal record. And he figured out that if he goes to trial, no jury will want to believe an ex-con like him. And the risk is that he may likely spend more time in jail if convicted than will be the case if he accepted the plea deal. So he was in for accepting the plea deal. But just before the plea deal was finalized, something dramatic happened in that case. Mr. Park discovered a Western Union money transfer receipt. And so what has Western Union money transfer receipt got to do with the crime? Well, that receipt has a timestamp on it. And that timestamp showed that at the exact time when this crime in question was being committed, Mr. Parks was 50 kilometers away in different parts of the town in a Western Union money transfer shop where he was wiring money to his girlfriend. That discovery was a perfect alibi, as Mr. Park would not be in two places at the same time. So what does this tell you about AI facial recognition technology in this case? That it got it wrong, very wrong. But that notwithstanding, it took Mr. Park another whole year and some lawyer fee to get the court to throw away the charges or the charges against him. And this raises the question then, what exactly is facial recognition technology? And why does this technology really suck when it comes to identifying people like Mr. Park? And what are the implications of this error in identification? So, facial recognition technology is an AI-based biometric technology or an AI-based biometric system that employs computer vision to identify individuals based on their unique facial features. So it works by translating an image of a face into a mathematical data or computer, so that computer can analyze and compare the images. So what the system basically does is to detect a face either in a still image or convert a video image of a face into a still image, then develop a unique biometric template of that face. And it developed that unique biometric template with dots representing unique features in the face. For example, the size of the nose, the distance between the eyes, the facial contours like cheekbones and others. So all these unique facial features are translated into dots that creates a unique template which is unique to a particular face. So basically, facial recognition technology generates personal information from personal information. That is, a picture, a still image, is now translated into another personal information, a biometric template that is unique to that particular face. And it recognizes in the loose term of recognize a face by comparing one facial template, biometric template, with another to see the level of similarity between the two. So it's able to match similar or identical facial templates. So facial recognition technology does not really recognize in the context of human recognition. It recognizes face in the context of one facial template being matched against another facial template. So in the course of my presentation today, I'm going to examine the legal and ethical implications of public sector deployment and use of facial recognition technology, with particular attention to two sectors, namely policing and immigration system. I'll go ahead to develop, of course, the concept of algorithmic racism as a framework for understanding how facial recognition technology embeds and legitimizes racialized bias within an ostensibly neutral technology systems. I'll demonstrate how contemporary facial recognition technology mirrors old racism in the Jim Crow era or Jim Crow system. And I will conclude, of course, by developing a framework for the use or maybe probably non-use of facial recognition technology. Now, it's important to note here that facial recognition technology, of course, is part of the broader artificial intelligence technology system. And hence, it is not immune from other bigger problems you find in artificial intelligence technology. And one big problem, of course, is the fact that artificial intelligence technology is not bias-free. AI has big problem of bias. And that may probably make you wonder then, how does bias get into an AI system? Well, there are many ways bias can get into an AI system. And we've just kind of, for now, for the purpose of this presentation, we're going to focus on three ways. One, which is the most unlikely of them all, it's when an AI tool is deliberately designed to generate a biased outcome. Now, I must acknowledge here that this is very rare, but where it happens, then it will be a clear case of bad faith engineering. Another way, it's where a biased data is used to train an AI system. Here you have the concept of garbage in, garbage out. AI is not a laundry machine. If you feed it with biased data, it's going to absorb everything in that data, the beauty and the ugliness of that data. It's absorbed by the system and regurgitated by the system. So when a biased data is used to train an AI system, that AI system is inevitably going to end up generating biased output reflected or manifested in the data used to train it. Another way bias could creep into an artificial intelligence technology is where an AI tool that is trained on data that is unique to a particular environment, it's now deployed to an environment different from that in which it was originally trained. There's high likelihood it's also going to generate a biased outcome. So artificial intelligence technology, AI facial recognition technology also has its own issue with this general problem in AI, which is bias outcome. And the bias in AI facial recognition technology is manifested by way of accuracy rate in recognition of or identification or recognition of faces. So a key concern with facial recognition technology is that it does not equally, or it does not work equally well for everyone. Even when vendors promote the high overall accuracy rate of artificial intelligence technology, artificial intelligence facial recognition technology, research has consistently shown that the technology performs very differently depending on a person's race, skin color, and gender, which is, of course, the problem of bias we have highlighted at the beginning. In particular, facial recognition technology does terribly bad job when it comes to recognizing darker skin tones. In particular, darker skinned females or Black women. They are more likely to be misidentified than any other gender or racial group. One of the most influential studies demonstrating this problem, of course, is the gender shade research, which examined the accuracy rate of commercial facial recognition technologies out in the market. And it examined the accuracy rate across some demographic groups. While these softwares were shown to perform with high accuracy rates when it comes to identifying white male faces, the gender shade shows that accuracy rate dropped dramatically when it comes to recognizing darker skin faces, and as, like we noted earlier, darker skin females. The research results from gender shade studies was also further collaborated by another research that was conducted by the US National Institute for Standard and Technology, NIST. It also shows or illustrates the high error rates in facial recognition technology, identifying individuals from darker skin, with darker skin colors, especially darker skinned women. So, what then is the implication of this racial gender bias in facial recognition technology? Well, of course, as you will expect, such high error rates will have some serious consequences, especially when it comes to the use of this technology in the criminal justice system. Now, before we come back home, let's start from US, where there has been well-documented cases of forced arrest arising from use of facial recognition technology by the police. The pictures you see here are pictures of some of the documented cases of forced arrest arising from police use of facial recognition technology. So these are basically situations where facial recognition technology has matched a criminal suspect to an individual in police database, resulting in the arrest of that individual, only for it to emerge that the individuals actually has nothing or have nothing to do with the crime in question. We have discussed earlier at the beginning of this talk the case of Mr. Major Park. Mr. Park was not alone. There was also the case of Randall Reed. Randall Reed was arrested for a crime that was committed in a state he has never been to. In the case of Ms. Portia Woodruff, 8 months pregnant woman, was actually arrested of all crime for the crime of carjacking and robbery. I do not know an 8-month pregnant woman that will basically kind of put herself in a situation where she has to commit that kind of crime. But that notwithstanding, the police officers that showed up in her house actually went on to arrest her, detain her for 8 hours for robbery and carjacking, until it became evident that this woman has basically nothing to do with that crime. So for some identification by facial recognition technology, who actually have some serious implication as illustrated from these cases. Now, let's leave the US and come back home to Canada, and then see how this tool is being deployed in the public sector here. And then we'll also see if the problem we have seen across the border also have some implication back home here. So in the course of my research, I focused on I'm going to focus my presentation on 2 sectors, like I noted earlier: the use of this technology within the Canadian immigration sector, especially immigration enforcement, and also in policing. Now, when it comes to use of facial recognition technology in Canadian immigration system, there are 2 ways this technology could be used, and that is what is known as face verification and face identification. I will explain these technical concepts. So with regards to face verification, this is known as one-on-one model or mode. So to illustrate, if you're a Canadian citizen, let's say you've traveled outside Canada, you're coming back home, of course, you need your Canadian passport, right? So in immigration, at the airport, you normally have what is known as immigration kiosk, right? Where you go, basically, screen yourself. And how does this work? You stand before the kiosk, you scan your passport. Now, your Canadian passport has a tiny chip embedded in it that has a copy of your mugshot when you apply for the passport. So that passport mugshot or passport photo, it's embedded in a very tiny chip in your Canadian passport. So in this immigration kiosk, when you scan your passport there, it reads that tiny chip that contains your passport. Then it goes ahead to take your passport photo on that stand. Then it now makes a comparison. The passport on that tiny chip and the mugshot that had just been taken at that point, it compares the 2 using facial recognition technology. Remember, the facial recognition technology develops a biological template of your face. Now it now compares those 2 biological templates as in one-on-one to see whether they match. So if they match, basically tells the system, the person standing before you here, it's also the person on that chip. So a match is made, you're good to go. Welcome back to Canada. So that's a very good example of one-to-one mode. Then the second example is one-to-many or one-to-n. This is referred to as face identification. And this is normally used in the case of application for immigration documents, especially like foreign nationals. So in the course of submitting your immigration application, you include a passport photo or maybe one that is taken at the office where the application is submitted. What it simply does is to generate a biometric template of that photo and then run through a huge database of other photos to see whether there is a match. So if previously you have applied for a particular immigration, or you have filed an immigration application under a different name, and now you basically come in with another name, it's now able to run through that database and say, okay, this person that is appearing before here as Mr. James White, his face matches another individual in our database that probably goes by the name of James Black. So that kind of course, triggers further verification to see whether somebody is kind of trying to misrepresent themselves or lie about their identity. So that's the case of one to many match. And this is the most problematic use of this tool or this technology because of the likelihood of a false match, or what is referred to as a false positive. Now, my research when regards to the use of AI in the Canadian immigration system, there are two things that stands out with regards to that stands out in my research. And one is the fact that there is clear evidence of racial bias with regards to the use of facial recognition technology in the Canadian immigration system. And I will cite many cases and discuss many stories highlighting this finding. Second observation, of course, is lack of transparency with regards to the government department's deployment or use of this technology. And from an ethical perspective, legal and ethical perspective, these two findings are troublesome. Now, I will go further with regards to the use of this tool in the immigration context. So in the course of my research, I was able to review 7 documented cases before the Federal Court of Canada, where Canadian authorities represented by Immigration, Refugee and Citizenship Canada, IRCC, and Canada Border Services Agency, CDSA, has sought to remove individuals from Canada based on alleged evidence from facial recognition technology. Excuse me. My research shows that 7 of the cases here, all the individuals involved are Blacks. 4 of the individuals are Black women. And this is disturbing because Black women, that racial and gender group has been shown, this is the racial and gender group where the technology has been shown to manifest its worst error rate. So let us examine some of these cases and go further to highlight the racial bias that has been evident in the deployment of this tool in immigration enforcement. The first case I'm going to discuss with you here is the case I refer to as the Somali tool. That is the case of Barre versus Citizenship and Immigration Canada. In the case of Barre versus Citizenship and Immigration Canada, so this case involved 2 Somali women who made successful refugee claim in Canada. So they basically arrived Canada from Somalia, made successful refugee claim. They were granted refugee status. Many years after their successful refugee claim, the Minister for Public Safety, represented by IRCC and CDSA, brought an application before the Refugee Protection Division. That was the government department that actually conferred their refugee status. They brought an application before the RPD to vacate their refugee status on the ground that these women misrepresented their identity as Somalis, when in actual fact, they were Kenyan nationals and not Somali nationals. So how did the minister get to know that these women are Somalis, are Kenyans and not Somalis? We'll find out. So the minister evidence, of course, included evidence that were alleged by the applicants to have been generated from Clearview facial recognition technology that matched their face to 2 other individuals that have entered Canada as international students from Kenya. So the Refugee Protection Division vacated or revoked the refugee status of these women, resulting in them bringing an application before federal court by a process known as judicial review for the courts to review the decision of the tribunal, that is the Refugee Protection Division. Now, one of the issues that arose in the course of the judicial review at the federal court is whether the minister used facial recognition technology in the comparison of these 2 photos. That is the photos of the 2 Somali women in their refugee application with the photos of the 2 other individuals that were alleged to have entered Canada as Kenyan nationals, who, of course, which the minister is now alleging that those individuals were actually the same as the 2 women here who claims to be from Somalia.
Wasn't alleging that?
The minister
Was not alleging that?
No, the individuals were alleging that they were alleging that facial recognition technology was used in making that comparison. And the reason why they make that allegation is based on known error rates of facial recognition technology in recognizing individuals from that racial group. So one of the important, of course, determination that has to be made here and there is whether facial recognition technology was used. If facial recognition technology was used, then that decision will be susceptible to challenge based on the fact that these are women, not just women, but Black women. And here we have body of evidence that shows that this technology has very high error rates in recognizing individuals from this racial group, which imply then that there might have been a mistake in comparison in that or high error rates in the comparison made of those two photos. But for now, it's an allegation that is being made. So one would have expected the minister to come out and say, well, I did not use facial recognition technology in making this comparison. Or, yes, I used facial recognition in making the comparison, but here it's additional step we took to make sure that this individual is actually, or these individuals are actually the same as this individual. I mean, commonsensically, that is what one would have expected, but that wasn't the case here. The minister was neither transparent nor forthright in either accepting the use of the technology or denying the use of the technology. Rather, it asserted that under Section 22, subsection 2 of the Privacy Act, we are not allowed, or we are allowed to protect details about our investigation.
We just use that.
Okay. Right. So the minister is basically relying on the provision of the Privacy Act to withhold disclosure of what technology was used. Now, at the initial hearing at the RPD, Refugee Protection Division, the minister, the RPD has accepted, of course, the minister's evidence with regards to the match of the two photos, but it refused or rejected the applicant request that they have made at that tribunal to compel the minister to disclose the source of the comparison. So at the tribunal, where the refugee status of these women were revoked, the minister refused to disclose the source of the photo comparison. And now at the federal courts, when that decision or revocation, the decision was being challenged, the minister still was bent on refusing to disclose the source of the photo comparison. At this point in time, it was rather relying on a legislative provision in Section 22, subsection 2 of the Privacy Act. So the federal court judge there, Justice Gao, accepted the fact or the applicant position that facial recognition technology was used in the photo comparison. And it also noted that the minister cannot make a blanket reliance on the Privacy Act to withhold the disclosure of the technology used in making that photo comparison. But it is also important to know what the court said, or some important pronouncement the judge made in its ruling. It noted that the applicant submitted that facial recognition technology is unreliable pseudoscience, junk science, which has consistently struggled to obtain accurate results, particularly with regards to Black women and women of color. They, that is the applicant, the court went on to note, cite a study on facial analysis algorithm, which found that darker-skinned females are the most misclassified group with error rate of up to 34.7% as compared to error rate for lighter-skinned males of 0.8%. 34.7% error rate on one side, darker-skinned female, 0.8% error rate on lighter-skinned male. That is a very huge gap. So the federal court, of course, granted the judicial review and then sent that matter back to before the initial tribunal to take a second look at it, what is known as redetermination. Now, the Barry and Canada case was the first case to come before the federal court where the use of facial recognition technology or alleged use of facial recognition technology in refugee revocation by immigration department But that case was also an eye-opener because for me, even as a person who have been involved in the Canadian immigration system as a lawyer for a long time, and also as someone who have also been working in the area of facial recognition, artificial intelligence technology for a long time, that was the first time I actually got to know that the immigration department actually uses facial recognition technology, which in the course of this presentation, I'm going to highlight why that is problematic, especially in the context of transparency when it comes to government deployment or use of artificial intelligence technology. So after the Barra case, the Barra case was the first, but definitely not the last. Another case also came up before the federal court. That is the case of Abdel and Canada, citizenship and immigration. The case of Abdel and Canada, very similar, if not identical, to the previous case. This one also involved a Somali woman who has also made a successful refugee claim in Canada. Many years after her successful refugee claim, the Minister for Public Safety brought an application to have her refugee status revoked because her face matched some other individual who have entered Canada as a Kenyan national or Kenyan citizen. So in this particular case, the applicant, of course, the refugee status was revoked at RPD, Refugee Protection Division, resulting in the federal court litigation. And in the federal court litigation, the applicant argued that the minister must have used Clearview AI, to match her face to some millions of other faces in the immigration database. But the problem with them here is that they, unlike the case of Barry, where an attempt was made to compel the minister at that initial tribunal to disclose the technology used, in this case, they made no request for that disclosure. And this was problematic. Now, but one thing I want to highlight here is the reference that's often made to Clearview AI or Clearview facial recognition technology. Now, I don't know how many of you here are very familiar with the Clearview scandal, because before Clearview scandal, very few people even knew what facial recognition technology was, except maybe probably for those who use it to unlock their phone. Clearview scandal was one scandal that made facial recognition technology popular and notorious. Popular in the sense that it opened the eyes of many Canadians to the fact that there's a particular technology known as facial recognition technology. Notorious in the context that it was a bad publicity for facial recognition technology, because Clearview was basically scraping images of individuals in their social media and were using it to build their facial recognition technology, which many Canadians saw as disgusting breach of their privacy. So associating that unethical practice with a particular technology, of course, is not a good PR for that particular technology, Clearview technology. So many people who knew about facial recognition technology often associate it with Clearview. So you find that in most of these cases, the allegation with regards to use of facial recognition technology is often pushed to Clearview AI, which of course, is not a good thing for that technology. So in this case also, the minister here denied using Clearview AI technology and insisted that they use a traditional investigation technique. And there are two things problematic with this. The minister denied using Clearview AI facial recognition technology. Does anybody discover some kind of fault in that denial? Can anybody here discover a fault in that denial? Yeah, okay.
They probably used a different facial recognition.
Thank you. Exactly. So it's like if I tell you, okay, you know what? I haven't drank Coke in the past 1 year. That does not mean that I haven't drank Sprite or Fanta in the past 1 year. So the denial here was strictly construed to one particular facial recognition technology, Clearview facial recognition. And I can tell you that the minister might actually be saying the truth. Yes, they did not use that technology, but there are many other brands of facial recognition technology. So that was a kind of an ingenious denial. Now, they went further to say that we didn't use Clearview, we used traditional investigation technique. What the heck is traditional investigation technique? So what exactly is that? So the case of Abdul was not as successful as the previous case, and the reason, of course, can be found in paragraph 35 of the decision. The judge there acknowledged the witness with facial recognition technology as being common knowledge. However, he said the applicant's argument is undermined by the fact that they did not seek direction at the Refugee Appeal Division on the method or process used, but she proceeded to make her appeal argument based on assumption without any evidentiary basis that such software have been employed. This was merely speculation, particularly in the face of the respondent's uncontroverted assertion that an exhaustive search has been conducted using traditional investigation technique. Whatever those techniques were, no inference can be drawn that they included facial recognition software in absence of supporting evidence. So in the case of Barry, from day one at the initial tribunal, they have made a request for the minister to disclose the technology used. They not only made the assertion that facial recognition technology was used, after making that assertion, they now applied for the minister to be compelled to disclose the technology used, because that information is information outside their control. It's within the control of the minister. So they have fulfilled their obligation by requesting that that disclosure be made from the other end. In this case, that request was not made. They just made an assertion without any evidentiary basis to back up that assertion. And the court found that problematic. So the failure of Abdul was merely on technical ground, and hence is not an assertion that the minister does not use, or that it does not really make a finding that that technology was not being used or that it was being used. But one thing that I want to draw from, or I want to highlight from the case of Abdul, is the consistent lack of transparency that has become a kind of common denominator with regards to the use of this technology by the immigration department or the minister. Now, after Abdul, one more story, one more case, AB versus Canada. Now, this is probably one of the most disturbing cases here because it raises some ethical and legal issue with regards to sharing of information between government departments. The case of AB involved a Black woman, yet another Black woman from Cameroon who had made a successful refugee claim. Years after her successful refugee claim in Canada, she walked into the Ontario Ministry of Transportation to have her photo taken for a driver license, an Ontario driver license. The MTO staff took a photo. They ran this photo using facial recognition technology. So this is what we have earlier described as one to many, one to n. So they took that one photo and ran it through the MTO driver license database. And in the course of that, of running that, of that processing, there was a match. It struck a match with another biometric template on the database. And that biometric template happens to be some other individual or another person with a different name. So based on this information, they actually passed this information to IRCC, Immigration Department, without the knowledge of this woman. Now, looking at this issue there are many ways to look at this issue. I'll just take a break and then from this story and then come back to it. One, MTO is a provincial government department. IRCC is a federal department. These are two levels of government. Before there can be any sharing of information between the two departments, it must be based on an information sharing agreement or contract between the two. Secondly, it is very important, at least for the purpose of transparency, for individuals to know what government department is using facial recognition technology. I resided in Ontario for many years, and for many years, I do recall walking into MTO offices to have my photo taken for driver license, but I had zero knowledge that MTO uses facial recognition technology, and that was never disclosed. So these are some kind of issues that arose because actually in the course of this research, when I came across this case, I have to file an access to information request with MTO, trying to find out if they have any information sharing agreement with the federal government, with the immigration department that actually justified the transfer of that information from MTO to IRCC. And my access to information request never disclosed, or among the information that was disclosed to me, there was no information sharing agreement between the two government departments or the two. So which of course raises some serious legal issue with regards to the transfer of that information. So that's one issue. Now, coming back to the case itself. So IRCC, of course, being in possession of this information, they brought a refugee revocation or vacation application before RPD, and they did so successfully. The Refugee Protection Division vacated or revoked the refugee status of this woman. Then she, of course, went to federal court for judicial review of that decision. At the Refugee Protection Division, before the federal court, at the Refugee Protection Division, she actually requested for the Refugee Protection Division to compel the Ministry of Transportation agents to appear to testify in evidence as to what technology was used to match the faces or her face with the other individual in the database. Unsurprisingly, the minister opposed the attempts to compel that MTO agent to appear to testify with regards to the technology used. And the position of the minister was actually upheld by the RPD. RPD refused to compel that individual to appear to testify. So what I'm trying to highlight here are what these three cases, there are many of them, there are 7 of them in this research, but I do not need to review the other, but the ones we have reviewed so far, what we have seen so far, it's a case of consistent lack of transparency with regards to the use of this tool. And also another important aspect, which of course goes to the ethical dimension with regards to the use of this tool, is why will the government departments continue to use this tool in identification of individuals from racial and gender group where the technology has been shown to have its worst error rate, and that is Black women. In the course of our discussion further, we are going to see the very serious implication that will have. But before that, in the course of course, because of this obvious denial and, absence of denial and absence of admission, more like kind of trying to hide in between. So what I did in the course of my research was to make make an access to information request with regards to the use of facial recognition technology by the immigration department. Now, you'll recall in all these cases, there's no clear denial whether they use the technology or admission whether they use the technology. So I made an access to information request and then got this huge amount of disclosure. And within this disclosure lies this straw in a haystack, to use that term. This was a PowerPoint slide. I think it was a PowerPoint slide that was developed for instructional purpose within the department. This particular page of the slide, what we are not currently doing. If you go to the third star in that slide, I will read it out. It says black box decision making. We do use black box technology, and they define black box technology in brackets as AI systems that use unknowable and unexplainable internal logic, that they use it in some capacities, including email triage and facial recognition. So that fact they have basically shied away in all the litigation. Their own internal documents show that they are actually using facial recognition technology. So if you're actually using it, then why not own up to the use? Why not be transparent about the use? As a lawyer and as an individual, one thing I do know is that when a government department is hiding something, it kind of gets me curious to want to know what exactly they're hiding because it's actually there may be more to it than it's obvious to the eyes. Yes, please go ahead.
I've got a question here.
Yes.
You're talking a court case where the government comes back and says, and tells you, are telling you they will not indicate how they identify this person as whatever it is they identified her as.
Mhm.
We know the technology is not reliable.
Yeah.
Can't you exclude that completely from the hearing? I mean, in a sense, if I'm claiming she's a refugee from Burundi or something like that, your response, either I have to prove it, I'm supposed to prove it. I'm supposed to demonstrate my technology, I'm using reliable methods.
Yeah.
Or I'm going to argue that I'm highly skilled at identifying these things or something like that. If I just vaguely say, no, I can't tell you how I figured it out, and I've got tools that don't work.
So it's not that this tool doesn't work. It's just that it works, but with very high error rates, right?
That's not working.
Well, so it doesn't have to be absolutely accurate. When it comes to the high error rate, at least for the purpose of judicial determination, it goes a long way in determining what weight you will give to evidence emanating from it. It doesn't necessarily mean that you have to exclude it completely. I mean, if something has, let's say, 65% accuracy rate, that is high accuracy rate, but not, it's problematic, but not, it's high, but also problematic. So that evidence now, if it is 65% accurate, that may probably make me think as a judge, well, if it is 35% error rate, then there's likelihood that you got it wrong here. I may not accept this as a basis for revoking this person's refugee status because of the high error rate. But that would be different where it says, okay, this technology that has its 5% accuracy rate match this individual. But in addition to this, here are also some other additional evidence that we have been able to gather that collaborate this is 5%. Then that will give you a safe room for conclusion, as opposed to relying solely on this. I will not, as a judge, rely on this tool alone to revoke somebody's refugee status because of the risk involved. Because you have to compare the risk in revoking that status with the high error rate. So it's not a case of, the government just deny. I mean, there's nothing wrong with coming forward and say, yes, we use this tool, but we did not rely on this tool alone. Here are also some other additional information we relied on that collaborate what we are getting from this tool. So I think that would be a safe way to go about it, as opposed to throwing away the evidence completely. There is evidence acts that guides what evidence is admissible in judicial proceeding or not. If the evidence was obtained by illegal means, that may form a very good legal ground for throwing it away, especially if it was obtained in ways that violate the charter right of the individual. But in this case, it doesn't really fall within that high threshold. That evidence is still admissible, but you have to make a determination as to how much weight you are going to attach to it. And that weight will rank higher if there are other evidence corroborating this particular evidence. Yes, please.
Maybe I missed this, but what does AA stand for here?
AA?
Yeah, so the department is not currently using AA.
I think that's probably automated algorithm or something like that.
Oh, okay.
Yeah,
Okay.
yeah.
That's somebody else's slide, it's not yours, right?
Yeah.
Sorry.
Yeah.
Sorry?
Oh, he said.
No, this is not my slide. So this is a document. This is a document from the access to information request. So this is a slide. It's just that if you look at the top right there, it's a very tiny script, unreadable script there. So it's a slide that was used for, it's an instructional slide that was used by IRCC, maybe probably in the course of one of their instructional sessions. So now let's now go further to another public sector that is crazily falling in love with facial recognition technology in Canada, and that is the police departments. So any record of use of facial recognition, well, just to start with, police use of facial recognition technology in Canada started on the cloud of secrecy. Police in Canada secretly deployed this technology without any public knowledge about it. Their use of this technology was revealed through investigative journalism when it emerged that police departments, including including the RCMP and some municipal and provincial police department, were actually using Clearview AI facial recognition technology. And that's, I believe, pissed a lot of Canadians off because of the unethical way Clearview approach Clearview adopted in gathering photos it used in training its AI algorithm. So that revelation about the secret use of Clearview AI by RCMP and other police departments in Canada resulted in a pause to the use of this specific brand of facial recognition technology, but it did not result in prohibition or ban of police use of facial recognition technology. So since the Clearview scandal, police interest in facial recognition technology has actually intensified with one of the most brazen recent efforts to integrate facial recognition technology into police body-worn cameras. So what we're seeing today is a shift from use of facial recognition technology in retrospective image analysis towards a real-time or near real-time facial identification using this technology, which of course significantly expand or has the implication of significantly expanding potential legal and ethical impact of facial recognition technology. Now, why is this use of facial recognition technology by the police of concern? What are the ethical and legal concerns that arises with police use of facial recognition technology in Canada today? Well, let's look into, of course, a case study here, which is the use of facial recognition technology by the Edmonton Police Service. Now, this is a very recent but concerning development with regards to police use of facial recognition technology. On December 2nd, 2025, the Edmonton Police Service called a press conference. At that press conference, it announced that by the next day, that it was going to be deploying facial recognition technology in police body-worn cameras. So basically, facial recognition technology will be embedded in police body-worn camera. So as basically, as police officers are walking the streets of Edmonton, they are basically taking the faces of everybody on that street and running it subsequently, for the purpose of that pilot program, running it subsequently on police database to try to identify among those individuals serious criminals, people that have very serious criminal record or outstanding warrants. And that project was going to start the next day. It will run for 1 month as a pilot project. Then after that 1 month, they will not decide whether they are going to deploy the use as a real lifetime, because the initial phase is that police body cam will be, facial recognition technology will be embedded in police body cam. Police body cam, as they walk the streets of Edmonton, they basically take pictures, recordings of faces of individuals that come in contact with the police on that street, and then subsequently run the identification. So after that 1 month, when they eventually now decide to unleash the program will be running live. So if you are walking on Edmonton Street and passes through a police officer, there is high likelihood that your face is automatically being run in a police database somewhere to find out whether you're a serious criminal with an outstanding warrant. That was a very serious use or deployment of facial recognition technology. And in fact, the Edmonton police proudly announced that they are the first police force in the world to deploy that technology, as if that was a thing of pride. Why is this use of facial recognition technology in this context concerning, or why should it be of concern to Canadians, not just Edmontonians? Well, there are many issues here because successful deployment of that tool in one region will inevitably open the door to other regions to start with. But there's even much more to that. First, police body-worn cameras were originally deployed as a tool of accountability. But the social contract we had with police is that, okay, you guys are going to wear this tool. It's going to record your interaction with members of the public so that we can hold you to account as police officers, how you deal with the public. So police body-worn camera kind of became the public's eye on the police officers. It becomes a tool for the public to basically watch the conduct of police officers. But now, basically, what we have is an attempt to retrofit that tool, to reverse it. Instead of the tool watching police officers on behalf of the public, the tool is now being used by the police officers themselves to watch the public. That is concerning. What is more concerning is the fact that the company that produces this tool, Axion, has their own ethic board, has actually warned against the deployment of facial recognition technology in police body-worn camera, right? Now imagine a restaurant owner who prepares food and warns that this food should not be served to humans, right? And then suddenly, somebody in that restaurant decide, oh, this food tastes delicious. Let's serve it to humans to eat. So if the developer of the tool, their own ethic board says, do not use this on body-worn camera, and Edmonton Police Service decided that this is a very good thing for us to use in our police body-worn camera. So that shows you how concerning this is. If it is so concerning to the person that stands to profit from the deployment of that tool, then that's really should be a big deal. Thirdly, no privacy impact assessment. Now, remember we noted earlier that facial recognition technology basically deals with processing of personal information. It picks one personal information and processes it into another personal information, which is a facial image, which is personal information because your facial image is unique to you. It's your personal information. From that image, it generates a biometric template, which is also unique to that image, which on its own, it's also another personal information. So in deploying facial recognition technology in police body-worn camera, it's basically going to take facial images of individuals on the street, which is unique personal information, and then generate another personal information in the form of a biometric template. Ordinarily, this will require such use of technology or artificial intelligence technology will require privacy impact assessment before their deployment. But in this case, there was none of that. As of the time this tool was being deployed, the Privacy and Information Commissioner in Alberta was not even aware. There has not been any privacy impact assessment. Then you talk about the lack of transparency and public consultation. Edmonton Police Service went public on December 2nd to announce that on December 3rd, they're basically deploying this tool. No member of the public was even given any opportunity to voice their concern or lack of concern about the use of the tool, which is very, very problematic. But having stated that, let's now go on to look at the legal implication from police use of this tool, especially in the context of police body-worn camera. There are many charter right obligations or charter right implication that arises here from deployment of this technology in this context. First, of course, is Section 8 of the Charter. Section 8 of the Charter deals with unreasonable search and seizure, right? Facial recognition technology on police body-worn cameras basically results in a warrantless and suspicious search of every face of every individual that comes within the close proximity of that police officer or those police officers wearing these tools. So basically, if you're an Edmontonian walking on Edmonton Street and you come across a police officer wearing wearing this particular tool, you are basically having your face searched against police database without your knowledge, without your consent. That is a clear breach of the highest rights Canadians have in Canada, or one of the highest rights Canadians have in Canada, which is the Charter right, the right against unreasonable search and seizure. There is also Section 7 of the Charter, which is deals with life, liberty, and security of the person. So Section 7 of the Charter is engaged when people are subject to constant biometric monitoring. That makes them feel that they are being watched, and being watched in that way kind of constrains your life, your daily life. So you're basically walking across this deal. That uneasy feeling when you come across police officer, okay, my face is being basically scanned and it's being searched against police database. I mean, in a police database. How about freedom, Section 2, freedom of expression and association? Canadians have the right, of course, to public protest, right? Of course, within, peaceful protest as opposed to violent protest. It's part of the highest law, highest right Canadians have. Now, think about it. If you know that your presence in a public square, engaging in public protest will result in your face being scanned by police officers there and then being run in police database, how willing will you be to engage in public protest? Well, you probably, for people who probably, well, I have nothing to hide. I have a clean rap sheet. They can go ahead and, search my face. Yeah, very few Canadians or many Canadians will go ahead because they know that, well, I'm not going to be arrested. There's no outstanding warrant. But this charter right is not only aimed at protecting people like you and me who have clean rap sheets. It's meant at protecting the right of the general Canadian public, the right to be able to freely express themselves. So any police use of artificial intelligence tool that constrains on that right has some charter implication, and it has some serious consequences with regards to, the rights of Canadians. But one of the charter rights that actually should be of very much importance to us in this conversation, of course, when it comes to racial bias manifested by this tool, is Section 15 of the Charter, which is, of course, the guarantee or the equality guarantee, right? The right of individuals not to be discriminated on various enumerated grounds, of course, including gender, race, among many other factors. So that guarantee right, of course, will be deeply implicated because substantial research has actually shown that facial recognition technology is consistently less accurate in identifying darker-skinned individuals, darker-skinned women, and indigenous people, as well as other racialized communities. So the implication here is that there is the burden of misidentification, which falls substantially on individuals from this racial or gender group. And of course, this will result, especially in the context of policing, it will result in over-policing of a community that has already been subject to over-policing already. So it's not even a case of, that burden, disproportionately putting that burden on them. It's a case of, basically legitimizing that disproportionate burden on this community. So having analyzed the use of this technology in these two contexts, public sector context, my research then goes further to kind of draw a parallel between facial recognition technology on one hand and Jim Crow laws. Now, for those of us who might not be familiar, of course, the Jim Crow, it's a term that most of us in this part of North America are familiar with. But for emphasis, I would like to know that when we talk about Jim Crow laws, we're talking about a series of state and local regulations that enforce racial segregation, primarily in some parts of United States during the during late 19th century and mid 20th century. So these Jim Crow laws and regulations deprived African Americans of many rights and also excluded them from certain spaces. So Jim Crow is primarily rooted on racial segregation and discrimination, or systemic racial discrimination. They were part of institutionalized racial discrimination that sought to maintain white supremacy as well as control over Black populations. My argument is that the well-documented racial bias in facial recognition technology today in many ways mirror the ugly Jim Crow laws of the past. In the context of modern technology, racial bias in facial recognition technology represent a continuation of the systemic racial issues that were characterized by Jim Crow era, although doing this in a very different, subtle form. So let's make that comparison, starting with spatial and temporal exclusion. Jim Crow laws basically excluded Black individuals and people of color from certain spaces that were described as white-only spaces. So as a person of color or Black person, you don't have any place in that space. Your presence in that space is excluded. How or in what way does facial recognition technology seems to perpetuate that exclusion today? Well, my argument is that the inaccurate recognition of darker skin faces by facial recognition technology will also achieve that same aim of exclusion from certain spaces, because it may result in individuals with darker skin tone being excluded from certain spaces. To illustrate, let's go back to the immigration example I gave earlier, right? Now, under international law and Canadian law, refugee protection status are conferred on individuals escaping persecution. Under our law, they are granted status here in order to prevent them from returning back to that agent or space of persecution. But one of the cardinal requirements for the grant of that status lies on identification. Before you're granted that status, which allows you to remain in the Canadian space, you have to be identified. Now we're seeing a situation where facial recognition technology is now being used in that identification process. And what is the implication? Now let's go back to our error rate, 34.7% for one group, 0.8% for another group. So if you are a white male escaping persecution, whether from across the border or from whatever other country in Europe, if you find yourself in Canada seeking that status, with the aid of this tool, you have 99.2% chances that you will be accurately identified by this tool, making it possible for you to be conferred with that status and hence being able to remain in this space. If you are a darker skinned female escaping persecution from Somalia and you find yourself in this space, there is 34.7% chances that you will be misidentified by this tool. And that misidentification will result in your removal from this space. So what difference does it make? The only difference is that Jim Crow, the removal was deliberate. In facial recognition technology, it's not deliberate, but as a result of operation of algorithm and data. But what matters is that at the end of the day, whether that individual is able to remain in that space or not is being determined by this tool. So the adoption of this tool may result in darker skinned individuals being excluded from the Canadian space, especially when it is used in the context of immigration, which was exactly what Jim Crow law sought to achieve in the past, excluding individuals from particular spaces based on the color of their skin. Now, perpetuation of discrimination is also another similarity between the two. Jim Crow law explicitly enforced racial segregation and discrimination, right? Facial recognition technology I argue, serves as an inadvertent but potent tool for enforcing racial bias and discrimination through algorithmic biases and flawed training data that subtly embed racial discrimination in its output. So Jim Crow law, it's explicit. Racial segregation and discrimination was explicitly authorized under Jim Crow law. Facial recognition technology is not explicitly designed to achieve that objective, but because of algorithmic biases and flawed data, we end up seeing the same output or outcome under Jim Crow law manifesting itself subtly in this tool. Then another, of course, comparison I sought to make is the legal and social implication of Jim Crow law and facial recognition technology. Under Jim Crow law, Jim Crow law was an integral part of the legal system in that era. It was a law that was passed by individuals elected to make law, right? So they make these Jim Crow laws to use it as an exclusionary tool for segregation and discrimination. Now, when it comes to facial recognition technology are not deliberately designed to exclude individuals from they're not in this particular space. Facial recognition technology has not been, or the bias in facial recognition technology, the racial bias in facial recognition technology has not been explicitly codified in any law in Canada, like Jim Crow law. And I can assure you that we will never have a situation where any legislative body in Canada will explicitly codify racial discrimination in any Canadian law. I mean, we have made much progress in terms of racial justice that even if you elect white supremacists in any legislative body, they will not go as far as, basically entrenching racial discrimination in law explicitly as we have in Jim Crow era. I mean, we have made some progress that those ugly pages of human history have been left behind for good. So while the racial biases in facial recognition technology has not been and will never be explicitly codified in our law or legal framework in Canada today, but the fact is that that same objective is being, it's kind of swiftly gaining the semblance of the racial bias in facial recognition technology is kind of swiftly gaining semblance of legal legitimacy as a result of covert integration of these tools into government operation and law enforcement. So even though the idea is not less codified racial bias in policing or in immigration enforcement, but when you adopt a tool that has that element and use it in this government department or sectors, you are inevitably codifying the racial bias that comes with that tool in your government operation. So that at the end of the day, it is basically achieving the same result in a more subtle way as Jim Crow law did. So even though it's not expressly codified in law, the result from operation of the law tends to subtly manifest racial biases and discrimination. So having analyzed the implication of this tool, of course, having raised the ethical and legal concern that comes with this tool, the next question then, of course, or the next step, of course, will be to develop the framework for use of these tools in the public sector. Now, let's not make a mistake about it. These tools are not inherently evil. They can be used for some good, just like any other tool you have, right? If you have a gun, there can be good use for it, and there can also be bad use for it. The same also applies to knife. So the best way or a policy framework or legal framework would be one that helps the society, especially the public sector, to know how to make the best use of this tool while at the same time addressing these issues that we have addressed or identified, which is, of course, the racial bias issues and others. So The question then is, what legal framework or governance framework can we develop that will help guide public sector integration and deployment of this tool? So in outlining this framework, it is important to note that artificial intelligence technology, including facial recognition technology, is a constantly evolving technology. And as the technology evolves, the governance framework will also evolve along with it. So I developed what I refer to as the bright line constraint for high-risk deployment. And it is my position, my argument rather, that at this point in time, it is appropriate to ban all real-time facial recognition use in public spaces and in police body-worn cameras. Those are very high-risk deployment of artificial intelligence technology. And the charter rights of Canadians at this point in time far outweigh any benefits that we stand to gain by use of facial recognition technology in this context. That is in the context of real-time facial recognition in public spaces and in police body-worn cameras. Secondly, mandatory impact assessments, transparency, and independent evaluation. Before deployment of any artificial intelligence technology tool, including facial recognition technology in any public sector, such deployment must be preceded by mandatory impact assessments, privacy impact assessment, as well as race-based impact assessment. Now, what we have often heard is, marketers or vendors of this tool giving us the general accuracy rates of these tools. Oh, this tool has like 90% accuracy rate. Oh, that is high enough. But what they fail to tell you or mention is the accuracy rate when it comes to subgroup. They fail to mention the fact that some subgroup have higher risk than the general group. So when we talk about impact assessments, we also need to understand what is the error rate for subgroups, especially when you're deploying it on groups that research has basically documented the risk this tool poses to that group. Like in the context of facial recognition technology, it's well documented today that there is high risk when it comes to deploying this tool to darker-skinned individuals, darker-skinned women. So when you are deploying this tool in public sector, you don't just take the overall accuracy rate. You need to understand what is the accuracy rate when it comes to deployment of this tool among this marginalized community. That should be an important tool or information or assessment made before deployment of this tool. And of course, the issue of transparency cannot be overemphasized. And one of the things we have noticed so far, especially in review of the cases, the federal court cases we have reviewed, is the lack of transparency that have often been evident in deployment of this tool. And that lack of transparency is not just limited to facial recognition technology. You find that in almost every public sector deployment of artificial intelligence technology. The fact is that artificial intelligence technology in our ramification is a black box technology, and we all know that. And when you're deploying a black box technology and you choose to do that so secretly, it raises more suspicion than is necessary, right? So that transparency kind of even goes a long way in helping address public concern about deploying a sort of mysterious black box tool already. Independent technical evaluation is also important. When we talk about technical evaluation, it's not just technical evaluation or this tool has been evaluated by this particular body. The third party evaluating the tool must be financially and institutionally different from the vendor or deploying agency. And this will prevent a situation whereby maybe third-party evaluators or research centers are basically evaluating tools that are being marketed or produced by corporations that they rely on for funding. The conflict of interest there, of course, will be very obvious, and it may not really result in the kind of independent evaluation that is necessary or important for this tool. Limited use in narrowly defined and legally constrained spaces. Like I noted earlier, artificial intelligence, facial recognition is not all bad tool. They have some good use. Some good use they could be put into. So these tools could be used within a narrowly constrained and defined spaces. But my argument is that even in the context of that use within that narrow space, facial recognition technology should never serve as its sole or primary evidence for decision making in public sector. And this brings me back to the question you asked earlier. Evidence arising from these tools or output from these tools should always be backed up by or collaborated by some other evidence before it's used. It should never serve as the sole basis for decision making in public sector. There should always be human in the loop. And the human in the loop here is not just any human that basically, like the case of Miss Portia Woodruff, police officers that runs a facial recognition technology and it strikes a match, and then you now go to arrest the woman for carjacking and robbery, and you see an 8-month pregnant woman before you, and nothing in your head tells you that something is wrong somewhere. And then you just go ahead and effect the arrest because facial recognition technology matched. There should be human in the loop. And the human in the loop here means that the individual in that loop should also be an individual who is explicitly trained and knowledgeable about the error pattern and racialized risk associated with this tool. So, like I noted, these tools are constantly evolving, and as they constantly evolve, the governance framework for them should also evolve along with their new use. So at this point in time, I think this would be an appropriate point for me to stop the presentation, and then I'll welcome any question you might have.